Just so you know, I've just started the recording as well. So you're all on camera.
Okay.
All right. A few more people still signing in, but we might get started. Thank you for your patience, everybody, and welcome to this fantastic event. Thank you for joining us this evening or this morning or this day, wherever you're coming from today. So we'll be diving into a fascinating and really important discussion today about the legal structural roots of the climate emergency and an introduction to how we can rethink responsibility for our shared commons. Our two fantastic speakers this evening, who I'll introduce in a moment, will outline a new approach to recognising the legal status of the Earth system that will enable us to tackle climate change together, the Earth Condominium concept. So Michelle Maloney, the founder and leader of Australian Earth Laws Alliance, is unfortunately an apology this evening to events outside of her control. So I apologise to all of the enormous fans of Michelle like me out there. She's really disappointed also to miss this event, but I'm personally very grateful to be able to step in and to be part of such a fascinating event. Before we begin, let's take a moment to all remember that we are each on the land of First Nations peoples, First Nations. In Australia, the sovereignty over this land has never been ceded. I'm currently coming from Turrbal and Jagera land in Mianjin, otherwise known as Brisbane, and I personally pay my respects to the elders past and present of this land and to all First Nations around Australia. And I pay respects and particularly welcome to any First Nations with us today and to the First Nations throughout this country. I invite you all to write into the chat whose country you are joining us from this evening. So this evening is hosted by the Australian Earth Laws Alliance. You're probably all familiar with them, given that you're here with us today. AILA, if not, is a national non-for-profit organisation whose mission is to increase the understanding and practical implementation of Earth-centred governance in Australia, with a focus on law, economics, education, ethics and the arts. AILA's work is inspired by the theory and practice of Earth jurisprudence, which is a governance philosophy and growing social movement. Earth jurisprudence proposes that we rethink our legal, political, economic and governance systems so that they support rather than undermine the integrity and health of the Earth. I might actually share the screen just in case anybody isn't familiar with AILA to give you a little snapshot of the great work that they're doing. I'll just get it up on my screen. Hopefully you're all seeing the website earthlaws.org.au of the Australian Earth Laws Alliance. So you can see the diversity of the work that they are undertaking in trying to move us to a more sustainable, interaction with this planet and with each other. I really encourage, if you're not familiar with the work of AILA, please have a look at the amazing work that they're doing. It's really progressive and it's where we need to be in terms of ensuring that we are making the changes that we need to in our cultural relationship with the earth and each other and in our legal system. They have elements around arts and religion. They're completely holistic in their focus in how to solve the dilemmas that we're facing together as a society. So AILA works to build long-term systemic change so that human societies can shift from human-centered to earth-centered governance. Their vision is to create human societies that are connected deeply to and love the living world, live within their ecological limits and enjoy productive, sustainable economies that nurture the health of the wider Earth community. So I think we can all agree that's exactly what we need to be doing. So I'm very glad to be a big supporter of AILA and that AILA actually exists thanks to the great work of all those involved and particularly Michelle Maloney. But coming back to our great and important event this evening, we are joined by two fantastic speakers. Our first speaker will be Paulo Magalhães, who is the founder and president of Common Home of Humanity. Paulo is a jurist and researcher at the Centre for Legal and Economic Research at the University of Porto in Portugal. In 2007, he published The Earth Condominium, From Climate Change to a New Juridical Conception of the Planet. In 2016, he was co-editor of the SOS Treaty, the Safe Operating Space Treaty, a new approach to managing our use of the Earth system. Paulo will discuss the legal structural roots of the climate emergency and provide an introduction to how we can rethink responsibility for our shared commons. He discusses a new approach to recognizing the legal status of the Earth system that will enable us to tackle climate change together. As I mentioned, this concept of the Earth Condominium. We'll hold off questions till the end, but please feel free to pop them in the chat, and then we'll have our two presentations from Paulo and Anna, and then we'll have plenty of time for a discussion at the end. So without further ado, please take it away, Paulo.
Hello, thank you so much for this invitation and to share with you all the work that I've been doing for several years. So let's start for the presentation. I will share the screen. One moment. Let me. Okay. I will talk about something that usually people doesn't talk, is not discussed. That is the legal status of climate. That I think is really the, as you know, who are jurists, without a favorable legal framework, it's impossible any human action. And people, this start to be discussed in the 80s. And after these initial discussions, it was never discussed after this. And after 25 years of discussions and negotiations without results, we have to rethink or to think about what is not working. And as you know, we have 10 years to avoid the limiting of 1.5 Celsius target. And we are in this moment with 430 ppm of CO2 in the atmosphere. If you reach the 450, probably we are pressing a tipping point. So what makes us to believe that this time will be different from the others, when we know that according to a very recent report about Paris Agreement, we know that all the promised reductions of emissions of CO2 will only reach the 1% in 2030. And to reach 1.5 Celsius, we need to decrease the emissions, not in 1%, but in 45%. So we have 10 years to make all these changes, all these paradigm shift, and to make this, what makes us to believe that this time will be different from others, and this will be a crucial decade. And the question is, what I will say, try to show that the discussion of the legal status of climate, that is also of the system, I will explain later, is not a theoretical question, is the fundamental question. As we will see, climate is not a common good. And this is the question. We are trying to manage a common good that is not recognized a common good. And this makes all the difference, as we will see. And so this is probably more than a climate change, more than a problem of emissions of CO2 and other gases, or it's a legal problem. And we need to, and the question that Einstein very well explained, we cannot continue to make the same and to say this time will be different because we will shout louder for climate emergency, we will shout louder for multilateralism, and to wait that in the day after will be different from what we have been doing the last 30 years, and waiting different results without changing the conditions and the rules of the game. And this is the question that we have to consider, to discuss in a serious way, and how a common norm of humanity wants to, with Stockholm Plus 39, I will talk about this. We have the 50 years of the United Nations program that will be celebrated in 2022. This year we want to organize a Stockholm Plus 49, because without a paradigm shift, what we have until today, it's mitigation and incremental improvements. This is the proof of this is that we only achieve 1% of decrease of emissions in 2030 in the pathway that we are now, and in a very serious way. What is needed to do that is going to, it's beyond to shut down. Okay, what we have been doing is to shut down that we are in the emergency, but we do not take the structural conditions that are needed to have a collective action. Okay, and here it's the role of law, not the role of law of making sanctions, is the role of law of organizing relations in a global scale and to manage a common good. Let me. So this is the paradigm shift between the outhouse pathway and to a stabilized pathway. What is missing is not a question of technology, and it's the most basic condition for human action. This is already what I have said, because it's not enough to shut louder. What we need, I don't know if you know the work of Eleanor Ostrom in defining the conditions that are needed for managing, to have a collective action and to manage successfully a common good. The first one is to define the common good. The second is reciprocity. And reciprocity means that we must have a congruence between the rules of appropriation of the common good and the rules for provision of the common good. And in climate, we have known these two first steps are not in place. We haven't defined what is a stable climate as a common good that belongs to all of mankind, and we have no reciprocity between who provides a stable climate and who make the appropriation of stable climate. Okay, and without these two first conditions, the others will not happen, and we will not have confidence. We will not achieve agreements, and we can achieve agreements, but the agreements will not work because these rules are valid not only for a small group, but to all mankind in a global scale. Because confidence is something that emerges. Confidence is not something that we can put in a law and in the day after we start working together. This is something that must be built and have conditions to be possible to emerge. And the first step, to define the common good. What is our common good that is beyond the territory? As you know, international law is still looking to the planet as a territory of 510 million kilometers square, and this planet is much more than a territory. All the planets that we know have a territory, smaller or bigger than Earth. What makes this planet different from the other planets is a system that throughout the history of our planet has many different ways of working. Okay, the system, the only one that we know is it's there in the Holocene epoch, is the only one that have the conditions of stability in climate, that is a pattern, as you will see, is a pattern of working, a pattern of functioning that system that put a stable climate inside a natural envelope of stability. Okay, and this is our most important common good that is not territorial. For the law, in this moment, the global commons are only the leftovers of the divisions of countries, because international law is still looking to this planet as a territory. And this planet is much more than a territory. The most outstanding characteristic of this planet is the system that supports life, that has no boundaries. That is, this pattern is intangible. It's not matter that we are talking, it's a way of function, some kind of software. Okay? And this software, it's what supports life on Earth, is not the territory. And sovereignty is a territorial concept. Okay? This is the first, trying to define the common good. When I talk about the envelope of stability, I'm talking about this. Here you have the size of the ice on the Arctic, and you see this. You see this, all this variability, and after in the Holocene, you have like this. Okay? Agriculture began 8,000 years, 8,000 years ago. And this was the basis that allowed human societies and all the other species that share with us the need for these ecological conditions. We must think that the Holocene corresponds not only of the opportunity for human species to build one civilization, but also for all the other species that we know that was a boom in biodiversity on Earth, because the conditions of stability for humans are favorable for many other species, okay? And this is, the question is, when we talk about the common norm of humanity or the common norm, or our common norm, we are talking about what? About the planet, the territorial planet, or these conditions here that support life on Earth that are not territorial. Okay, this is not a territory. This is the intangible conditions that allow life on Earth. And without this, probably, this planet does not function as our common norm. So our common norm, this is the main sentence of common norm of humanity, is to say our common norm is not the planet Earth. Our common norm are these conditions that allows humans and other species to live on Earth, that support life on Earth. Okay, it's our common norm is not a territory. It's not a territory of 500 millions of kilometers square. It's a system. And it's intangible, it has no borders. And what is a stable climate? A stable climate is this pattern that you see here, pattern of stability. When the ice, you have ice and frozen in Texas, what is happening? This pattern is changing because we are changing the totally free energy in the planet, because we are eating with the CO2 and other gases, we are eating the global temperature, and we are changing the thermodynamics between the ice and the equator line, okay? And we are changing all the thermodynamics with the difference of temperature. We are changing the circulation of the oceans, the speed of the circulation of the oceans, and we are changing the pattern of stability and predictable dynamics of that system. A stable climate is a well-functioning Earth system. A stable climate is an outcome of a well-functioning Earth system based on a well-functioning biosphere. Okay, and this pattern of stability, what you see here is the quantity of water. Okay, what you see here is impossible to divide. We can divide airspace and to say this is our airspace. I have sovereignty, and I can say to a plane, you cannot enter in my airspace. But we are not able to divide the chemical composition of the atmosphere, when we cannot divide the chemical composition of the oceans. We cannot divide the circulation of the air circulation or the atmospheric circulation, or to divide the ocean circulation. So this is another plan, a functional plan of the planet that is invisible to international law, because we still look, international law still looking to the planet as a territory. And sorry, this planet is not only a territory. The most outstanding feature of this planet is the system. And the system does not exist for the law. And like this is a no man's land, intangible no man's land, where everyone use without rules, who make positive impacts are not compensated by the positive impacts for the provision of the common goods. And this is we are trying to reduce damage. And I will explain later about this. And the way we are looking to climate and to the system, it's impossible to restore the system, to restore and to maintain after, because the question is, let's put one possibility that we achieve 1.5 degrees. We achieve this. And after, how we will maintain in a permanent way the system and the stable climate in a permanent way? How we will do that? We need a legal framework to do it. And the first step is to accept that we have a system that does not exist for the law in this moment. So, as I have said, our planet is not a territory with a surface of 500 million square kilometers divided between states, where the global commons are only the territorial leftovers. In this moment, the global commons are the high seas, the seabed, Antarctica, very, very confusion situation in Antarctica. But the concept of commons in this moment is the leftovers of the territory. And you know that is not true. Climate is common, and it's not a concern. I will say this. This is a global common in the real world. It exists on the planet. It's not only a human concern. It's a common good that exists in the natural world. Okay, and to understand how the Holocene came out, we have to understand now that also climate is the outcome of the work of nature. The composition of the atmosphere that corresponds to a stable climate is the outcome of the work of the chemical work made by nature. Okay, here in this graphic, you see Earth with life and without life. See the different composition, absolute different composition of the atmosphere of our planet if you don't have life on Earth and with life. You know that when you have missions to other planets to understand if you have life or in a different planet, it's not necessary to ship to the planet. With the analysis, the chemical analysis of the atmosphere, we can know if this planet can have life or not, because there are some gases that only the process of life can produce these gases. So you see that a stable climate is based on a well-functioning biodiversity, and it was the outcome of the work of nature. And we are destroying nature, and we destroy the fabric that produces a stable climate. Okay, and the question is: this work of nature is invisible for the law and is invisible for economy, and we still consider the planet only as the hardware, this territory, and the software does not exist for the law. And the question is today, when Arvid Parl proposed for the first time the concept of common heritage of mankind in 1967, he tried that the oceans, the first proposal was that the environment of oceans became a common heritage of mankind. The question is that in the 60s, we have no scientific knowledge to define or to distinguish the marine environment from the space where the oceans are. You understand? The territory of the oceans, okay? We can divide the territory of the oceans, but we cannot divide the circulation of the oceans, the chemical composition of the oceans. Today, we have already the scientific knowledge to distinguish the territory from the quality of the territory. We have already the scientific knowledge to distinguish the territory of the planet from the state of the function of the system. When you saw the first the image with the Holocene, you see the history of our planet as 4.6 billion years, and we only on the last 11,000 years we have the system working in a way that is favorable for our species and many other species. So today we can define what are these conditions that put the system working in that way, okay, in this operating mode. And we have the planet boundaries that define the safe operating space for mankind, okay? So we have each one of these core drivers. The first three are the core one. We have already this scientific knowledge, and this space of this safe operating space for mankind is not a territory; is a quality space. So maybe law, to address this question, it's the time that law make a conceptual evolution to be able to explain the planet and the function of the planet that is the territorial approach is not able to do it. Law must go beyond the territorial approach. It's the only way to be able to explain and to represent how the planet works and to be possible for human societies to live inside this system, because we are part of this system. And of course, if we are part of this system, law must consider the system, and we must have a legal system that put rules for humans to live inside the system, because we belong to the system. If it was life that make a stable climate, we are part of biodiversity. When we breathe, we are making chemical changes on the atmosphere, like a tree, make chemical changes in the atmosphere when make photosynthesis. It's the same thing. Different gas, but these are the same operations, chemical operations that are produced on the system. So we still consider the planet like this, where the leftovers are the commons, and we need to make a common approach. It's a question of redefining the global commons, to think without redefining which is the global common, the real global common that unites us all, and to change the paradigm shift. This view of the planet, it goes with the concept, and this goes with the heritage concept, as we will see. And the first time that when in the 80s that climate entered in the UN agenda, the first proposal, because Arvid Pardo, the man that proposed for the first time the concept of common heritage of mankind, was a Maltese ambassador, and it was again in 1988 that Malta proposed to UN that declaration proclaiming climate as part of the common heritage of mankind. If this proposal was accepted in the 80s, for the first time, we will have a common good that exists and spans across borders, that exists inside and outside all the sovereignties in the world. But of course, the great question is, for the first time, the great challenge of that climate put for the law, because we have already many problems with our territorial division, with the problems with water and with the rivers and the oceans and so on, the problems that do not respect boundaries and species, animal species. But the question is, we can abstractly divide the space of the oceans and to say you cannot fish until there, and this line is one abstract line, but we can do it. We can divide the space of the oceans. We cannot divide the quality of the waters, but we can divide the space. As well in the atmosphere. The question of climate, we don't even can make any kind of division, even if it is a legal abstract division. It's impossible to make any kind of abstract legal division on climate. And this, if this proposal was accepted, it was a bigger revolution if the concept of common norm of mankind was one of the biggest revolutions, conceptual revolutions in the history of international law. If this proposal was accepted, it will be the biggest revolution that ever in international law, because for the first time, one of the first pillars of international law, that is the sovereignty and the territorial sovereignty, will be very different. Okay, because this is a good that is intangible, that has no borders, that and it's always circulating around the planet. There is no division, and it exists inside and outside the oceans, the atmosphere, the space, the airspace is always circulating. So this is a whole view with intangible global commons without borders. This was what will be happening. But this was made in 12th of September 1988, and after precisely in 6th December 1988, what was decided after the proposal of the government of Malta of conservation of climate as part of the common heritage. So two different concepts. The previous one is the stable climate as a common heritage. And the second is the climate change as a common concern of mankind. And here you have two completely different approaches to the problem. And do not forget that after this decision of 1988, it was reconfirmed in Rio in Rio 92, and still being the first article of Paris Agreement is climate change is a common concern of mankind. And let's spend some time try to understand the difference between one and another. In the concern approach, what we say is we are concerned about something, we are worried about something. So between us, we promise between us that each one will try to make less emissions. This is the question. The difference is, because the common good does not exist, to make positive actions on the system does not exist, because, for example, a forest that is cleaning the atmosphere for the benefit of everyone, like Amazon, like the forests in the north of Canada and Russia and so on. They are cleaning the atmosphere, they are making positive impacts in the common good, but because the common good does not exist, they are making benefits in the legal void. So this is the reason why we economy give value to the timber, but does not make visible the value of the work of nature, because the global common without borders does not exist. It's a legal void, and we have a system based on the negative approach. That is, each one will try to make less damage, and if I have a quota. If I make fewer damage, I can sell my quota of pollution to another one in the CO2 market, and the emission will be done by another one. And I earn money for making less emissions, but the guy that is permanently making the maintenance and making positive impacts to the common goods does not earn nothing. 2 weeks ago, we have access to in several news. We have the news that Elon Musk earned more money selling the credits of CO2 than selling cars. And this is the outcome of a concerned approach. We earn money for not polluting, and we do not earn money for making positive impacts on the system, because the benefits spread all over the planet, and all over the planet is a legal void for the law. The system does not exist for the law, and it is impossible to have in human societies one economic activity of restoring the system. And because we only give value to what is not the most important for us. What matters is the chemical work made by nature that make a stable climate and support life on Earth. Because the great question is that this system and this work do not stay with them inside the borders of any country. Because this work does not stay inside the borders of any country, does not exist. Does not exist. So the solution is, let's try to make less damage. We have a system of burden sharing. We try to mitigate the damage, but in the end of the day, it's always a negative sum game. Okay, each one tries to make less damage, but the sum of less damage is always a damage. It's a negative sum game. And this is the reason why, after so many years of efforts, what we will achieve in 2030 is 1% of reductions of emissions. And it is impossible to have one society that is able to put economy restoring ecosystem here. Because if I make this in my country, I will be, as Eleanor Ostrom explained, I will be the sucker. The others will absorb the benefits that I've been making to all the planet. The others absorb. I will not receive nothing. I will be the sucker. So without a legal innovation that accepts that without borders, that is not a territorial good, it's an intangible one, that is the system, we will never manage the system, because the first condition for to make a successful management of a common good is to accept that the common good exists and to define it. And after we define it, we can have rules for the appropriation of the common good and for the provision of the common good. In the system that we have now, what we have is we try to put some rules on the appropriation of the common goods, but we have no rules for the provision of the common goods. And if I have one emission, I can and I make fewer emissions, so I will sell the emission to another one that will make the same the emission. Or if I make an emission, I can buy to afford someone that make the sequestration of this emission. I can pay to it, but the rest of the forests that are cleaning the atmosphere for the benefit of all humanity, they are not in this game. They are outside the game because they are making benefits for everyone. And the everyone, the global, the system does not exist for the law, does not exist for international law. This is something that purely does not exist. So the concern approach is to keep the economic system that we have, that is a system that does not recognize the commons. in a system with commons, this is not a market because everyone has access to the common goods. We cannot put anyone outside this to the access of the common goods. So it's a system of management of commons that should have rules very different from a market. Must have one international institution that should be, for example, the United Nations, that makes the management of the positive impact and the negative impact and the redistribution, and to decide what are the ecosystems that must be managed in a permanent way to have the system working in a well-functioned system. And so here we have the negative impacts are value loss on the system, on the common heritage, and the positive impacts are value gains in the common heritage. The question is, what is wealth creation for societies? What we have now to make less emissions is only to avoid losses, but we consider as value to make less emissions. Okay. What really is wealth creation is the intangible work of nature. To make less emissions, it's only to avoid losses, is not wealth creation. What creates wealth for human societies is the intangible work of nature, and without this legal base, it's impossible to build one economy of caring and restoring a stable climate. This, as you can see, in this decision in 1988, what was decided is two different complete worlds. One world with a concerned heritage, with a concerned approach, or a heritage approach. That means that we have a common good in a global scale, and all the societies must be there to conditionate their functioning, where to make common benefits for the global are also value gains for not only for the country that makes, but also for all humanity. This is a completely different world that we have now. And worse than ever is to know that we have our societies full of intangible global legal goods like copyrights, like brands, like goodwill of enterprises. We have already, for example, without the copyright, it was impossible, or the legal division between the book and idea, it was impossible to have the society of knowledge that we have now. We have already recognized intangible natural goods in outer space law as the orbits and the geostationary orbit, for example, is because think on this. This is not space; is a pattern of function. And what we see here, this pattern of function of the system, is our heritage. Is a very well that we can already define this software, this pattern of function that is favorable for humankind as a natural, intangible object of law. And because it's intangible, I think that it's perfectly, we can conciliate with sovereignty, because sovereignty is a territorial approach. And this is a functional approach. Okay? It's very different. So the legal division that we have made between the book and the idea that allows the building of society of knowledge that we have today, this is before this legal solution. It was a mess. I read texts about it was on the beginning of 18th century, the first law about copyright in England. And this legal solution is the base of the society of knowledge that we have today, because I buy the book, but I do not buy the idea, because there are a legal division between the idea, and the idea is autonomous legal goods that exist per se, and we need to make the same fundamental legal division between the trees, between the trees and the work of the trees.
Sorry, Paulo.
Yeah,
I'm
the
so
time.
sorry. Yeah, we just have
The
to
time,
wrap up.
let me, so the rule of the game, the question that I have already, without this, we will continue to destroy the ecosystems because the work of nature does not exist for the law and does not exist for economy also. Eleanor Rostam that I have already talked, reciprocity and equity, and our proposal is the total amount of positive impacts on the safe operating space and the negative impacts, and to have a system of accountancy and compensating and governance of this common good. This is the game changer. Thank you so much. Sorry for taking your time. Thank you so much.
Thank you, Paulo. I'm so sorry to wrap you up. You have so much information.
No.
It's fascinating to share. So,
okay.
Yeah, that was just enthralling and a really enjoyable presentation reflecting on the reality of our climate as a common good. It's just common sense. It would be nice if it was actually reflected.
I think so. It's common sense. It's common sense, but it is not on reality. Thank you.
Yeah. So I have the great joy of now introducing our next speaker, Ana Pereira, a senior lawyer, director, and founder of the Instituto Internacional de Derecho y Medio Ambiente. It's a good test of my Spanish. So the International Institute for Law and the Environment in 1996. She holds 2 Master of Laws degrees in Environmental Law from London University and in International Legal Studies from New York University. Anna started her career at the Environmental Law Department at Allen and Overy in London in 1993. In 2001 to 2002 was Senior Legal Advisor for the 2002 Spanish European Union Presidency, focusing on the UN World Summit for Sustainable Development. She's worked in projects relating to environmental law and policy in different Balkan countries, Mexico and Turkey as a consultant for the World Bank, and the European Commission, as well as for the compliance mechanism of the European Investment Bank. She litigates on environmental matters and is a member of the IUCN Environmental Law Commission of the BODs of Oceania, UK, and the Common Home for Humanity as well. She's authored articles and books on environmental law, including a handbook on international environmental law and rights for Spanish media. And she's taught international environmental law and participates in UN environmental negotiations. Her areas of expertise are particularly biodiversity, climate change, and energy transition, water protection, and environmental democracy. So Anna is going to address this evening the topic of international environmental law and the Earth system, and we'll address the follow. Well, I'll let you. I won't give you too much of an intro, and you can introduce your own presentation because it's going to be a fascinating look through some very important questions, and I don't want to eat up more of your time. Thank you so much, Anna. Take it away.
Okay. Hello and good evening to all of you in Australia, and we are here in Europe, so it's good morning for us. So it's a pleasure to be here, and after the presentation of Paulo, I need to revisit international law. It is very important because, as he mentions, the system, the Earth system, is not reflected in international law. And of course, international law is based, and it has been developed in the last centuries. And I don't think the law is going to change quickly as it is necessary, although we need, as it is said in climate change negotiations, and when we fight climate change, we need science policy must be based on science, so science-based policy. But it takes time. So then we need to revisit international law and see how we can protect, or whether international law provides some elements as it is today to start addressing the Earth system before we reach all these changes that are necessary in the international legal system. So I'm going to address today principles of international and international environmental law for the protection of the Earth system, because I don't have the time to go through all the international legal system. And it has been already said by Paulo that the object of protection is the Earth system, which is the functioning interaction of the chemical, biological, and physical processes of the Earth. And it has 2 highly interactive components, which is the biosphere, which is the living part, and the geosphere, which is all this composition of the physico-chemical interaction, which is comprised by the climate, the hydrosphere, the geosphere, etc. And just to keep under the Holocene conditions, which are the emergent properties of the Earth system, the scientific community in 2009 developed the framework of the planetary boundaries. So then we have also to see whether law can be used to live within planetary boundaries. And we need to interpret the law in line with today's society needs. And as I said, I'm going to focus on principles of international environmental law because there has been an initiative at the UN level, which has been the process towards a global pact for the environment. This process was launched 2 years ago at the General Assembly with a General Assembly resolution, which was 72/277, which called for a process, a negotiating process, to see whether we could have a global pact for the environment comprising the main principles of international environmental law. And I want to revisit all these principles to see whether this can be useful for the protection of the Earth system. And this process is still ongoing. The process launched by that General Assembly resolution failed. It was not too successful, but there was another resolution as a result of that process, which is resolution of the General Assembly 73/333. And there is a call to see whether it will be possible in the future to have at least a high-level political declaration compiling the main principles of international environmental law. And I think that we have to go farther. We cannot stay only with the principles of international environmental law as they are understood today. So what are the main principles of international law and international environmental law that I will revisit for the protection of the Earth system?
Anna, I'm just going to interrupt very quickly, sorry, just to know, we're only seeing your first slide, the introduction. Should we be seeing further on? And it's not showing up in presentation format. I just wanted to make sure you're aware of that.
Okay, can you see now a slide which contains the principles, the list of principles?
No, only the title slide.
Okay, I don't know because I have in my computer in front of me. Can you see it right now? No.
I'm afraid not. Maybe it's the screen that you shared. Is it the same screen that you're looking at?
Yes, yes. Okay, let's see. Okay.
There we go. Perfect. Yep, now we see a principles list. Thank you. Sorry about that.
Okay, thank you for letting me know. It's okay. So then I'm going to analyze or revisit and quick. I cannot say I will analyze because it takes time to analyze all these principles. It's like it's almost a PhD thesis. So I don't have the time today to go through it. So the principle of sovereignty of states, the principle of permanent sovereignty over natural resources, and all these principles of international environmental law, and I will provide some conclusions, but it's very important to have in mind that all these principles, and particularly the principles of international environmental law and the principle of permanent sovereignty over natural resources, have been developed in the times of that the scientific community has said that we are in the acceleration stage. So it's after the 50s when all these principles started to be developed, and these principles are a result of society because always law reflects the needs of society. So let's go first to the principle of sovereignty of states. Okay, we need to think about, we need to have in mind that the sovereignty of a state is a principle of law, but it's also a political understanding. And as it is understood in the political context is very different as sovereignty is understood in the international legal arena, because sovereignty in the political context is always used as an absolute concept without any limitation. And we will see now that sovereignty has already limitations. Of course, I agree with Paulo that sovereignty, just it's for the tangible space, is for the territory. It doesn't reflect, perhaps, until it is understood today, the intangible functioning of the Earth system. So, and we need to consider this principle and to see the rights and obligations it entails, because when we take into consideration the Earth system, we have to know that it's not under the sovereignty of any state. As it has been said, it cannot be appropriated. But however, activities which are undertaken within the territories of states have impacts on the Earth system. And when I say impacts, I'm not saying only negative impacts, but also positive impacts, as it has been explained in the previous presentation. So the sovereignty, this principle of international law is a fundamental principle, but in the last years, I would say in the last 3 decades, or in the even before, it has been subject to limitations. And we will see by interpretation of the courts, of international courts in arbitration cases, but also when there has been evidences of the interconnectivity and the ecological interdependence of the planet, which is in line, or it's the Earth system, how it functions. So how this evolution of this concept, of this principle, implies that there is a limitation, at least today, to respect the sovereignty of other states. But we will see that also implies to respect areas beyond the sovereignty of other states. And we will see how that, because of other principles of international environmental law, there are also limitations on how states use their own territory. So this limitation already entails the obligation of cooperation, and cooperation in good faith. And I think we require cooperation to protect the Earth system. So what are the elements of sovereignty? Sovereignty requires, or it's an element, is the jurisdiction over a territory and over the population of a territory. It has a duty of not intervention in the territory of other states or beyond the territories of states. And also it entails the dependence of obligations that has been accepted, obligations under customary international law and also under treaties. And what is this territorial dimension that Paulo was mentioning? Okay, the states have sovereign rights without limitations under the land, the subsoil, the internal waters as rivers, lakes, and the territorial sea, these 12 nautical miles, and the Earth space. However, under this territorial dimension, as we consider the concept of the Earth system, there are activities that takes places under these sovereign rights that have already impacts on the functioning of the Earth system. In addition, another territorial dimension is there is limited jurisdiction over contiguous adjacent territorial sea, which is another 12 nautical miles, the resources of the continental shelf, its seabed and subsoil, the economic exclusive zone, and certain fishing zones. And there are areas which are outside jurisdiction of any states, which are the high seas, the outer space, the atmosphere, and also many states include the Antarctic. So this is how it's today international law and how sovereignty applies. But as I mentioned, there are limitations limitations of activities that are taken under the jurisdiction of the states, that they cannot, and we will see now, they cannot damage the territory or the areas of other states or areas beyond the territories of other states. And those includes elements of the earth system. And this was the first time that this was analyzed. It was in an arbitration case in 1941 in a conflict between Canada and the United States. There was in Canada, probably, I don't know if anyone in the audience knows this case, but it's a classical case of international environmental law, which there was a smelter in British Columbia in Canada, and it was polluting. I mean, the pollution, the air pollution from this smelter was arriving to Washington State in the US. So there was an arbitral tribunal, and this arbitral tribunal in 1941 says that under international law, no state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes or to the territory of another or the properties or person therein, when the cause is of serious consequence and the injury is established by clear and convincing evidence. And this was already very similarly said in another case that was solved by the International Court of Justice in 1949, which is known as the Corfu Channel case. And in this case, the International Court of Justice declared that every state's obligation, so every state is obliged not to allow knowingly its territory to be used for acts contrary to the rights of other states. Okay, so the rights of other states. And we need to read all these principles as, or all these cases and with the needs of society today. Therefore, I think that here there is already some elements that the use of the territory of states cannot be used in such a manner that may put or may have an impact on planetary boundaries and push the planetary boundary under the uncertainty zone. I don't know if you are familiar with the framework of planetary boundaries, but I cannot explain now about what is the uncertainty areas of each planetary boundary. But I would understand this as there are already some obligations under international law. There is another principle which is really very linked to the principle of sovereignty, which is the principle of permanent sovereignty over natural resources. And as I said, this principle was developed when this acceleration, the third industrial revolution, started in the 40s. So, and this is a consequence of the history of our planet, and we are talking about of the post-colonial time when many countries wanted to take the control or recover the control over natural resources, and to do the practices as were done before by other countries, which was the exploitation of natural resources. And this was totally linked with the self-determination, and this is recognized in the United Nations Charter. So in this time, there was a link in many international covenants between the entitlement over natural resources and the self-determination of peoples. And there was a United Nations General Assembly resolution in 1962, which is resolution 1803, which already established the principle of self-determination, the link between the permanent sovereignty over natural resources and self-determination, but always says that it has to be done for the well-being for the well-being of the population. So I understand here, if you start exploiting natural resources in a manner that you have impacts on the Earth system, then you are not, in a sense, considering the well-being of your population. Then in 1974, it was approved the Charter of Economic Rights and Duties, which states that every state has permanent sovereignty over their natural resources and has the inalienable right fully and freely to dispose of them. So as you can see, this development of international law, it has been having impacts on our planet, because that's why there has been an understanding of this principle of permanent sovereignty over natural resources as putting, as allowing all the exploitation without limitation in those years. But of course, that was an understanding, but the International Law Association already in the 60s produced a declaration on the right to development. And they said that this principle is subject to the application of relevant principles and rules of international law. And therefore, this principle it was already subject when that declaration was developed to the Trade Smelter case, to the Corfu Channel case, and also to the duty not causing damage to other states. In fact, this has been, or this was reflected already in Principle 21 of the Stockholm Declaration in 1972, which declares that the right of states to exploit their resources, but in accordance to their own environmental policies, but also put on the states a duty to ensure that activities within their jurisdictions or control do not cause damage to the environment of other states or areas beyond the limits of national jurisdiction. So there we can see that this principle, it has their own limitations. And this has been developing and developing. And in the Rio Declaration, Principle 2 is the very same principle as the Principle 21, but it added, as it is here, as I wrote, and developmental policies. That was what it was added in the Rio Declaration. But many people thought, okay, it's the end, because if countries, they can exploit their own natural resources in accordance with their own environmental, but also developmental policies, this is going to be, again, the end. But there are other principles that are very important. And when you read the principles, they have to be read in jointly with the whole text. And Principle 3 established the right to development. And that right to development, this declaration said that must meet developmental and environmental needs of present and future generations. In addition, Principle 4, it says that in order to achieve sustainable development, environmental protection shall constitute an integral part of developmental processes and cannot be considered in isolation of it. Therefore, I read this principle as it has to consider today, when you read that principle today, it has to consider the planetary boundaries framework. So therefore, the planetary boundaries has to be considered in developmental processes. And I will say today, this is happening in some regions. Like, for example, the European Union has developed a framework based on the, which is called the Green Deal. And the Green Deal is taking into consideration the planetary boundaries. And as the European Commission said in its paper, its communication paper on the Green Deal, says, this is to live within the planetary boundaries. In fact, if you read today in the 21st century, this principle, I will say that there is an obligation today not to put under risk the Earth system stability and not to transgress the planetary boundary, because otherwise, for example, you cannot meet the developmental and environmental needs of present and future generations. So this is very important, always to read legal texts in the times when they are going to be applied. We cannot think that this principle only reflects what it was, or it was the intention when they were prepared during Rio or during the Stockholm Declaration. So now I'm going to go through the main principles of international environmental law and to see the relation with the planetary boundaries, because we need to maintain a safe operating space. I would say the condition of the Holocene to keep the Earth system under a favorable status. So we need to see whether these principles can be useful or not. First, we have, or I'm going to see the precautionary principle. And this principle plays a very important role in the framework of the planetary boundaries, because this principle is used also by the scientific community when they set the framework of planetary boundaries, and to see, I mean, as there are areas or zones in the planetary boundaries with uncertainty, then that's why this principle applies, because this principle that was first introduced, although there were declarations, but as a principle was first introduced in the Rio Declaration, entails that when there are threats of serious irreversible damage, the fact that there is lack of full scientific certainty is not reason for postponing or for taking measures. And so therefore, when there is like a risk that a damage might be caused, even simply a risk, it is important, or there is an obligation to take measures, and this put also an obligation on states to cooperate. So therefore, today, there is this need to cooperate in the light of current interferences with the Earth system, as well as with the status of some planetary boundaries, because these represent a threat of serious and irreversible damage. And today, the international community must adopt measures to face the Anthropocene. And this principle, it has been reflected in many international conventions, the United Nations Framework Convention on Climate Change, the Cartagena Protocol to the Biodiversity Convention, the conventions on the protection of the ozone layer, the Vienna Convention and the Montreal Protocol, for example, or those conventions on chemicals. So therefore, I would say that this principle is very useful today to protect the Earth system. We need to use existing principles to protect the Earth system, and this one is a very important one. And for example, in the Urgenda case, brought against the government of the Netherlands, the Court of Appeals of The Hague already used this principle to force the government of the Netherlands to increase its ambition by 2020 in 25% and not in a 20% as it was reflected in the legislation of the Netherlands. Another principle which is very important is the principle of common heritage of mankind that Paulo has already been explaining about it. And this is a principle that until now has been implemented for geographical areas and for resources beyond national jurisdiction. But I would say that we need a certain reformulation of this principle, because today applies, I would say, for exploiting resources, like as it is covered in the United Nations Convention on the Law of the Sea with the Seabed Authority. it is just a system to exploit and to distribute the benefits among countries for the exploitation of the seabed, which is beyond national jurisdictions. So we need to reformulate this principle, but it's a fact that it complies with many of the elements of what is required to apply the common heritage of mankind. First, the earth system cannot be subject to appropriation, as it cannot be subject areas which are beyond national jurisdiction. And it is required for common home of mankind to have a co-managing system. So countries must cooperate, and this is happening in the seabed, as I mentioned before. But we will need a treaty to organize this, and we will need an institution to organize this. And this has been already proposed of a treaty by the Common Home of Humanity, a safe operating space for humankind treaty. We need to share the burdens and benefits derived from the protection of the earth system. Also, it has been proposed an earth system accountants framework, but I want to be clear that we don't want exploitation as it is done, for example, today with the seabed, where it's a monetary interest. And also one of the elements of the common heritage of mankind is that that area has to be maintained for peaceful purposes. And of course, the earth system, it has to be dedicated to maintaining the safe operating space for humankind and also for the security of all of us. Okay, so let's go to the next principle. It's the principle of.
I'm so sorry to interrupt. I might just interject just to let you know we have 3 minutes until.
Okay. So I will go. Okay, I will go through very quickly. And okay, the common concern of humankind. I want to say that an author, Dina Selton, and a specialist in international environmental law, has said that common concern of humankind applies to issues of common concerns, which are those that inevitably transcend the boundaries of a single state and require collective action in response. So, okay, this is a principle that mainly speaks about the need for cooperation. It's another thing is how this cooperation works, which has been already explained by Paulo before. But this principle is just linked to the principle of common but differentiated responsibility, which is a very difficult principle in negotiations on climate change. And this was already reflected in Principle 7 of the Rio Declaration. Then we also have the principle of sustainable development, which all of you know, developed by the Brundtland Report, and it contains another elements. It contains needs and contains limitations. And there are elements on it that speaks about intergeneration equity, and we need to protect the earth system, the Holocene conditions for the future generations. Also, speaks about the use, the prudent, rational, and of an appropriate manner of the use of natural resources. And we need to use natural resources in a manner that keeps us within the planetary boundaries. And also the intragenerational equity as well, which speaks about the needs of present generations, about the needs of the peers. And these needs also to respect the planetary boundaries. And also the principle of integration, I already talked about that, which is about the need to integrate planetary boundaries in decision-making. And the principle of cooperation, I don't have time now, and I want just to share my conclusions. And I think, this is what I've been saying in my presentation, that sovereignty has to be interpreted and applied in accordance to the need of every generation. And generations today face the challenge to keep the Earth system in a Holocene-like condition. Today, sovereignty embeds interdependency, implies limits to its exercises. And for me, I would understand, or I will read today this sovereignty principle as that the states have under international law the obligation not to interfere with the functioning of the Earth system in such a manner as that it doesn't cause serious disruption to its fundamental processes. I think that existing principles of international environmental law can be useful for the protection of the Earth system. The right to development cannot be asserted at the expense of future and present generations by destroying the basis for human survival, which is a stable Holocene-like state of the Earth system. And today, states are obliged to cooperate in order to maintain the Earth system under a safe operating space. And thank you very much.
Thank you so much, Anna. That was brilliant. I'm so sorry to have to wind you up.
It's okay. I understand. So no, don't worry. Don't apologize.
Heard that you might have to go soon. And so I thought at least we can have a quick question. I see there has been a question just put in the chat, and there have been a few really interesting reflections put through in terms of the relationship between what you were speaking about and some of the areas of law. There was a question around power stations being regulated, which I saw was answered in terms of that being more a state-based kind of process for legality. However, perhaps there's applications that could be made to international law given the Paris Agreement and whatnot, and states' obligations to fulfill them. It was so fascinating to hear, I think, particularly how international law, it can, as a lawyer, it can be seen as having not much teeth, but it's also incredibly important in forming a mandate that really does have tangible impacts on states' actions and laws that come out for better or for worse. And so the principles you were talking about being in Australia are inclusive, actually implemented in our laws, but how well they're implemented is very variable. Important concepts like the precautionary principle, for instance, including in how power stations are regulated. We do have one question here from Sonia McKay about the possibility of an International Court of Justice case regarding the no harm principle and prevention principle, which relates to irreversibility as well. The possibility of this could be brought by a Pacific Island country on behalf of all regarding Australia's COVID gas-led recovery, and whether all could include Mother Earth as personhood. It's a great question. Did you have any thoughts on that, Anna?
Yeah, I really don't understand well what does it mean, the COVID gas-led recovery. It means that in Australia now there is an explosion of gas projects.
That's correct. Our economic stimulus that the government's trying to push through is very focused on supporting the gas industry, unfortunately, at a time when we're supposed to be reducing our emissions.
Okay. It's very interesting the question, because of course today we have scientific knowledge and we know that gas is not the solution for fighting climate change, that we cannot extend projects because then we will be keeping the same problem. And if we read the report of the IPCC on 1.5 degrees, gas has to go as well as coal. So therefore, of course, there is a possibility, and if a country takes a case against another country, as this has happened many times before the International Court of Justice, I don't think why. I mean, there is no limitation to that, and it all will depend on the court. I mean, sometimes courts tend to be quite conservative. But I think that today, given all these litigation cases, climate change litigations, the courts are being more open to new ideas. So I think that it's a case, it's a potential case, and cases must be brought to see how is the interpretation of law by the International Court of Justice. If you don't bring the case, you are not opening new in a kind of interpretation. So yes, I think that these principles of international law that I was explaining, that they will be useful, and the personhood of Mother Earth, I would say that it will be more important that that in the law it is recognized the functioning of the Earth system, because if we use the term of Mother Earth, or people understand that Mother Earth entails the functioning of the Earth system, because it's very important that we understand the same thing when we use a concept, because otherwise we won't, I would say, progress, that there won't be progress enough. Yeah.
Let me say also, about this. I remember when we were on the negotiations in the Global Pact, we had a meeting with the GULAC, the countries of Latin America and Caraïbes, and where they are the countries of the Mother Earth. And one of the first questions I made to the representatives of these countries was if the Occidental concept of their system and, you know, planet boundaries is the same thing of Mother Earth. And they say yes. Is the scientific explanation of Mother Earth. And this is a very important achievement, I understand it, because we have been talking about Mother Earth. We can give different names to the same things with different languages, a scientific language, empiric language, but we are talking about the same in a global scale. Is the Mother Earth a big machine? You know, is the same thing. The question is how to put this big machine, Mother Earth system, on law. If the question is, again, the question of commons. More important, the question is the decision of Australia to explore the gas and so on. If the common was defined and the impact of the common have a governance, probably Australia will have to make a different accountancy about the benefits for Australia economy and the damage that they are making to something that do not belong to Australia, but is a common good. And you are using a common good, you have to pay for it, not only to pay, but also to receive for the benefits that you are making to the common good. So you will change probably the way of function, you will operating to consider what is as a value for Australia economy if you have a common that is governed, and we have to consider not only your decisions but the impacts of your decisions in a common good that belongs to everyone. In this moment, the common good belongs to no one. This is the question. Mother Earth or Earth system is the same thing. You understand? It's very interesting because the question of Mother Earth, it has a long story in the history of human civilizations with different names. We call it different things, but every culture around the planet has this sense of something that is global, that is a great machine that works and keeps lives working. So science, Occidental science, called now Earth system, define what are the conditions that is the safe operating space, is the same thing on Mother Earth, is the same thing in different cultures, the big machine, the laws of nature, this is the same thing. And the question is how to put this on law. Now, to put on law, we have to define it. It cannot be an undefined concept. We have the scientific tools to do it now. So we can do it. And we have a lot of objects in international law that are intangible. Okay, international law, not in law. Why can't we now recognize that this planet is not only a territory? This is the question. how it's possible that in the 21st century, from a legal point of view, we'll still look into this planet as a territory, divided between states where the global commons are the leftovers.
That's a great segue, Paulo. I'm sorry to interrupt, but it's a great segue to our next question. Just I'm conscious of time. We have gone over, so thank you for everyone's patience and staying with us. So the next question is that we know that we need a new legal understanding, as you're both discussing. What could be the institutional arrangement for the management of such newly recognized commons, and is the sovereignty-based multilateral system able to deal with this?
We have one work done about the revamp of the Trusteeship Council in the UN. We think that is the most easy to do because it's a body already foreseen in the UN Charter. It's there. In this moment, there's no object to deal because all the territories have already, the situation of all the territories is already defined. So in 1992, it was, I think, in 1992, there was a Commission for Global Governance that proposed that the UN Trusteeship Council to give new functions to this body. And these functions should be the governance of global commons. The only difference between our proposal and the proposal of the Global Governance Commission is we should to include a new global common in this UN Trusteeship Council, that is the system. Not only the leftovers, but also the system, the climate, which the climate is the outcome of a well-functioning system. So to govern this, what each country inside their borders make to the system, and which are the limits, and to receive the money and to receive the compensations and to decide to invest to preserve these ecosystems. We know in this moment what are the key ecosystems in the planet that keep this system working well. How it's possible that we have no funds to keep these ecosystems working and support life on Earth? How it's possible? This is the question. It's a legal question. Before economic question or ecological question is a legal question. These territories belong to states, but the work that is made there are spread all over the planet. We have to find a legal solution for this. Thank you, Paulo.
Anna, did you want to add anything?
Yeah, I think that, okay, we need to, this is not an easy solution because we have a very well institutionalized system. And of course, the UN is the system we have now, but the UN is based on sovereignty of states. So we need, I don't know if we need an evolution or a revolution here. But as the subjects of international law today are the states, although there are many other subjects, and international law has evolved a lot in the last 40 years. We need to see that the advantages or disadvantages of having the Trusteeship Commission of the UN in charge of this, because we need a lot of mind changes, and unfortunately, there are many representatives of states that they still understand sovereignty as an absolute concept, with no limitations. And for me, the question that was posed before, it is very interesting on how using international law as you cannot use your territory, Australia, you can, or any other country, will start exploiting your gas reserves. And this is going to cause problems not only to the Pacific Islands, but to the entire system, to the entire climate system, which is the object of the United Nations Framework Convention on Climate Change. So not only the Pacific Islands, but any country could bring that case. But I know that in international law, not many countries will be interested because there are many countries that they are looking at gas as a solution, which is not a solution. But anyway, it's not an easy solution.
No, but a worthy one.
Of course.
I think I might wrap us up there then. I am just so grateful to both of you, Paulo and Anna, and to all of you for joining this evening. It's such a privilege in the world we're living. While it'd be great to all be in the same room, it's a privilege to be able to have the great progressive international minds such as yours, Anna and Paulo, to present to us this evening from the comfort of our own, wherever we're coming from, offices or houses. So thank you so much for your time, and all the best in continuing your very important work in these spaces. You're really leading the way, and I hope that our legal systems across the planet do catch up. Thank you all for joining us so much. I'm sorry we didn't get a lot of time for in-depth discussion, but I've really enjoyed seeing your comments and the discussion coming on through the conversation, the chat. This has been recorded, so if you knew somebody who wanted to come and couldn't join us, please tell them to get in contact with Ayla, and I'm sure they can make the recording available, or if you want to watch it again, I'm sure, yeah, they'll be able to make it available. So thank you very, very much. I'm sorry we can't give you a rousing round of applause for your fantastic efforts while on Zoom, but in spirit, I'm sure we all are. And I wish you all good days and good evenings. So yeah, thank you for your time.
Okay. Thank you very much. A pleasure. Bye-bye.
Lovely.
Bye.
Thank you.
Goodbye, Paulo. Goodbye, everybody.
Thank you so much. Thank you. Bye-bye. Thank you.